Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. We are now going to discuss a case law on the death sentence, commuting of death sentence to life sentence. When, if there is inordinate delay. While dealing with the case of State of Maharashtra versus Renuka Shinde and others in SLP number 12674 by 2022, day before yesterday, that is on 13/4/2023, Honorable Justice M.R. Shah bench, they have directed the state governments, including the governors of the states, to decide the mercy petitions as expeditiously as possible. Why? Because the accused may take undue advantage of getting them commuted to life sentence. You all know this. We have discussed umpteen number of cases. Normally, it is the duty of the state. It is the function of the governor of a state. It is the function of the president of a state, Article 161. So, to pardon. When any petition comes before him for pardoning, he has to give a decision, that to a reasoned decision, whether to allow the pardon or to dismiss the same. But if the file is kept on pending for years together with inordinate delay, with unexplained delay, with heavy delay, then the benefit should go to the accused and the death sentence will be commuted to life sentence. This happened in the case of very famous case, Jagdish. Jagdish versus State of Madhya Pradesh 2020. Likewise, Navneet Kaur versus National Capital Territory Region of Delhi 2014. And Union of India versus Dharampal 2019. Number of cases are there where because of the inordinate delay, the Supreme Court was forced to commute the death sentence into life sentence. So M.R. Shah said, do you want to take advantage by the accused persons in this line? Better you disperse them as early as possible. This is the synopsis of this case. Right. So please remember, the state of Maharashtra, they challenged the Bombay High Court judgment of commuting the death sentence to life imprisonment to the appellant. So the ground is inordinate delay, which is unexplained delay on the part of the state, maybe on the part of the governor also. You know the period of delay, 7 years and 10 months. So they are sleeping over the file for 7 years and 10 months. So Supreme Court remarked that it is true that the gravity of the offence definitely can be a relevant consideration. Just like our Billa Ranga case, you can't give them. So the gravity of offence is a very serious point to be considered, but the delay is irrelevant. Maybe 1 year, okay, 2 years, okay, but 7 years, 10 months, how can you sleep on the file? How can the file be keeping dust over it without any disposal? So please remember. Anyway, in this particular incident, the Honorable Supreme Court of India, they have modified the High Court order. Of course, life imprisonment is imprisonment. So the sentence as suggested by the Bombay High Court has been reduced to life sentence. But the life means till he dies. Latest this thing. So he has to undergo life till his biological death. So this is what is stated by the Honorable Supreme Court of India. How things are happening, the red tapeism, of course, even we can't find fault with the authorities also. They have got their own priorities. After all, tendering pardon is not an important issue for them. For them, so-called executive matters are there. They have to give so many GOs. Their administration aspect is totally different. But still, as they have got a function, as they have got a duty, functions and duties are correlated with each other. So they have to decide the case. Decide the case. If you wanted to pardon him, yes, pardon him. If you don't want to pardon him, don't give any leniency. Finish. Without doing that, if you keep on delaying the matter, then what is the result? So definitely, so that's why I told you in the interpretation of statutes also, whenever there is any benefit, that benefit should go to the subject, that is accused person. Same thing happened. So this is a very classic case. Please remember this case and inform your other persons also, because very important case law. Thank you.